Okay, welcome everybody to our webinar this afternoon on how advisors can leverage the recent 401k litigation. Your presenter today is Chuck Humphrey, and Chuck is, your profile just disappeared on me, Chuck. I gotta find your profile again. Okay, hang on.
I'm in the witness protection
Here we go,
program.
here we go. Chuck Humphrey is the founder of the law offices of Charles G. Humphrey. He's a former IRS and Labor Department attorney, legal counsel to a large regional bank and its related broker-dealer and mutual funds, as well as has practiced law in large firm settings and served as counsel to ERISA Fiduciary Responsibility consulting firm. 30 plus years as an employee benefit attorney, we won't hold that against you, Chuck, and actively involved in professional committees that advance and address important employee benefit issues, including as chair of the American Bar Association Tax Section Subcommittee on multiple employers, PEOs, and controlled and affiliated service groups, and the ERISA Fiduciary Responsibility Subcommittee. He is an original member of the IRS Northeast Pension Liaison Committee, and Chuck also writes and speaks frequently on employee benefit plan issues. His book, The Fiduciary Responsibility e-Source, is actually available exclusively on erisapedia.com. Chuck holds an undergraduate degree from the University of Michigan and a law degree from the University of Buffalo. He is a member of the New York and Washington, D.C. bars. So let me get back to the presentation. So my name is Chuck Gouge, and I'm going to be your facilitator today. On board with me is Joanne Pacina. She's going to be monitoring the question board that we have available. If you'll notice on your control panel that came up when you logged in to GoToMeeting, there's a little question section of the control panel where you can submit questions. Your lines are muted, but you can always chat or send in a question via that question box. Please send in your questions. We will try to answer as many as we can during the presentation. If you think of something afterwards, you can always send a follow-up question or comment to support@erisapedia.com. Chuck, you want to take it away?
All right, Chuck, thank you for that introduction.
Oh, one more thing, Chuck, I meant to say, and I always forget this, we are recording this presentation, so we will make a copy of the recording available as well as the slides. So we'll send you a link so you can either listen to it or send it to somebody else who wants to listen to it, or just review the slides again. So I'm sorry. Go ahead, Chuck.
Okay, that's fine. Thanks for the introduction. I'm feeling pretty old after you haven't gone through all that. Well, this afternoon I'd like to share with you my thoughts on the challenges and opportunities presented by last year's 401k plan litigation, and suggest how you can use it to build your practices and solidify your existing relationships. And I think you should think about it in this way. What is your value to clients if you help them avoid litigation or reduce the cost of litigation? What is your value to clients if you avoid a DOL investigation, or you make that DOL investigation a short one? And I know from experience that litigation and DOL investigations are very expensive. So I think there's a lot of value there in preventing or shortening or reducing the costs of all that. And you're in a great position to help clients prevent that kind of stuff. And I think it's in your interest to be proactive, considering the pressures you face. As we all know, you're in a very competitive environment. Fee information about your client plans is freely available on the DOL website, and that's information that can be used to undercut you and your relationships. You're facing decreasing margins. I read recently that a study showed that fees have decreased 30% since 2001. And then you've got something right on your plate right now. You've got the fiduciary rule that went into effect on June 9th. Then it's really a double whammy. You've got to figure out how to comply with it, and it's still in a period of flux. You've got the increased client scrutiny from the long debate over the rule that I think will only intensify. And just recently, it's interesting, I saw that the state of Nevada just passed a law that makes brokers and financial planners subject to a fiduciary standard. And I understand that other states are interested in maybe developing or passing their own laws. And another thing I saw the other day is that the CFP board getting into the act with its own proposed fiduciary rule. So you're in the spotlight, so to speak. Then we've had the 401k plan litigation over the last 10 years, and there have been over 75 lawsuits filed in this area, and they hone in with increasing precision on fiduciaries. And they've been largely at the large plan level, but I think we can see this activity maybe moving down to smaller plans. I saw yesterday a suit was filed against Nationwide involving a less than 30 person plan. Nationwide was charging a 1% asset-based fee for plan administration, resulting in a $635 per participant charge when the average per participant charge for administration is something like $64. So things are happening there. So all of this is really exacerbated by last year's litigation. And there's another thing I'd like to bring up, and that's healthcare costs. If you think about employee compensation as coming in three buckets, one being direct compensation, another being 401k contributions, and the third being healthcare, the bucket that's getting that compensation more and more is the healthcare bucket, and it's really competition for 401k money and to your businesses. There's an organization out there that's doing some very interesting work called Health Rosetta that's working on these issues right now and how to reduce healthcare costs. So maybe some of that money can be going into 401k plans. And I think advisors are going to have to be more active on this issue, but that's a discussion for another day. So the question now is in this overall environment, what does this 2016 litigation mean for you and your clients? So I have a question for you. What's the problem with ERISA from the perspective of a plan fiduciary? I think it's this. It really doesn't tell fiduciaries what to do when making important plan decisions. What is the appropriate process for deciding on plan investments? What is the appropriate process for choosing a service provider? How do you monitor it all? What's the right thing to do? There's no answer in ERISA. There's no playbook like the one Tom Brady has on Sunday afternoon to guide his efforts. Instead, ERISA has a standard that's very important, that sets general expectations for fiduciaries. And fiduciaries have to figure out what that means. So let's look at the specific elements of that standard. Fiduciaries have to act solely in the interest of plan participants and beneficiaries. In short, in making decisions, they can't think about anyone else's interests other than the plans. They've got to act for the exclusive benefit of providing benefits. That means to me, just figure out the best way to deliver benefits under the plan. And they must pay only reasonable expenses. So buy only what you need and don't pay too much for it. It's pretty simple. Then there is the prudence requirement. Fiduciaries must act with a care, skill, diligence, and prudence expected of someone who's experienced with plans. But what does all this mean? What does it mean to act solely in the interests of? What does it mean to act for the exclusive benefit of participants? What's the appropriate level of care, skill, and diligence? The rule doesn't say. So like if you're Tom Brady playing under this rule, he'd be told to act in the exclusive interests of Patriots fans and play like other professional quarterbacks. Not very helpful on game day. I've read the rule thousands of times and I can't find any specific directions in it. So planned fiduciaries are on their own in terms of what they have to do. And the basic approach they have adopted is process, procedure, and documentation. So this is called procedural prudence. So procedural prudence decreases the chances of being sued, and it decreases the costs of litigation and DOL investigations that I mentioned earlier. Whether it's picking investments or choosing service providers, you're in a good place if you follow a prudent process. But last year's litigation suggests that prudent process may not be good enough. So what do I mean? Well, let's start with the building blocks of a good process. I think there are 4. First, plan fiduciaries have to meet regularly to discuss important plan matters. Second building block, they have to educate themselves on their plan specifically. They have to know what their plan says, who the service providers are, what the relationships are, all of that. And then they have to understand benefit plans generally and the market for plan services. And thirdly, if you don't have the experience as a plan fiduciary, you don't have the expertise, you need to go find an expert that can help you out. And finally, you've got to document your decisions. It's really important to do that. But the upshot of the 2016 litigation is that even if you have a good process in place, you can still get sued. And I see 3 main vulnerabilities coming out of the litigation. They are the failure to use leverage. Second one, not doing your homework. And the third is a failure to predict the future. Now that last one is a bit of a joke, but what I mean is that plaintiffs' attorneys now are asserting that the quality of a fiduciary process should be measured by the result. This is a bit scary and I think quite a bit wrong, as I'll explain later. But let's look at leverage first. So everyone knows when you have a lot of money, you can usually get a better deal. If you have a lot of plan assets, you're going to get lower fees. And a $1 billion plan shouldn't be paying what a $100,000 startup plan is paying. So your response right now is probably, well, tell me something I don't already know. Well, here's what's new. In the Bell v. Anthem case, the Anthem fiduciaries thought they got a pretty sweet deal for their plan. They chose Vanguard funds at 4 bips when average fees were 25 bips. But that wasn't good enough for the Anthem participants. They said, well, wait a minute, we saw somebody get 2 bips, and you cost the plan $18 million. Now, excuse me, most neutral observers would say that 4 bips is pretty low, and that maybe the plan fiduciaries did exert their large plan leverage. But I think the lawsuit really focuses in on the question of how much leverage is leverage enough? How far do you have to go? And maybe we'll find out in this litigation, maybe we won't. But I think whatever the result, fiduciaries have to ask 2 questions when making investment and cost decisions. Did I get the best price? And did I document my decision? All right, let's look at homework fails. You can't make a good buying decision when you don't know the product or service and you don't know its reasonable cost. That goes for flat screen TVs and it goes for 401k plans. So this makes me ask the question, what was going on in the heads of the Fujitsu plan fiduciaries when they were making their decisions? First, they approved fees that were 3 times higher than the fees for similarly sized plans, or so it's alleged in the complaint. And second, they authorized custom target date funds managed by a manager that had no experience with target date funds. And that fund went on to significantly underperform other TDFs. So I'm wondering, did these fiduciaries ask questions like, what are other plans paying for similar services? Why use a custom TDF when less expensive off-the-shelf funds were available? Who's this manager? Who's the manager of the TDF? What's their track record? Can they manage a custom TDF? Well, we don't know the answers to these questions, but if the allegations in the complaint are true, someone wasn't doing their homework. So let's look at another type of homework fail. This might be called a failure to read the label type of fail. In LSV Fidelity, the participants in the Barnes & Noble plan sued Fidelity. They claimed Fidelity deviated from the traditional mix for stable value funds. That is, they invested in money market funds rather than in longer duration bonds. Why worry about this litigation? After all, it was against the manager, not a plan sponsor. Well, here's my worry. Shouldn't plan sponsors know whether the underlying investments in a fund reflect the stated file of the fund? I think so. To me, that means plan fiduciaries should be reading a description of the fund, and it also means they should be checking to see if the investment mix over time stays consistent. So plan fiduciaries need to read the label. Let's move on to failures to see the future. Everybody is clairvoyant, right? This is obviously not true, but the plaintiffs in the cases on the screen seem to be making that argument. In Pledger, the participants said that the money market fund the plan fiduciaries chose was not the right investment. They said the plan fiduciary should have chosen a stable value fund because it would better keep up with inflation. In the White v. Chevron case, the participants said quite the opposite. They said the plan fiduciary should have picked a stable value fund rather than the money market fund. What's a fiduciary to do? It seems like you're damned if you do, damned if you don't. But I don't think that's the real point of these cases. What's concerning in both is that the plaintiff said, you know, if you just picked the other investment, you would have done better. In other words, that what matters is the result, not the process. And this turns on its head all that we know about fiduciary law. We've had a saying for many years, ERISA attorneys, I think, have had this saying, there's no Monday morning, continue my football theme, there's no Monday morning quarterbacking in ERISA. That is, you don't always have to be right as long as you have a reasonable process in place. So I've identified 3 vulnerabilities in this litigation: leverage, or really the failure to use it, the failure to do your homework, and what I'm going to call in this last one is the failure to be clairvoyant. So where are these cases going, and what do they mean for you guys? Well, no one knows where the cases are going. They're just past the complaint stage and then into the pleading phase. Some will fail, maybe some of them will succeed, but to me it really doesn't matter. What has been put in play by this litigation is the quality of process. Is your process good enough? Is there a flaw in it? Have you done enough? Have you done too little? And there's going to be more of these cases, testing the limits of the law by plaintiff's attorneys. And this means there will be more exposure to liability and more risk for plan fiduciaries. And I think it's important to remember that this liability can, or exposure to liability can extend for years. The Supreme Court decision in Tibble a few years back suggests that that fiduciary responsibility is sort of self-renewing, ongoing, regardless of any statute of limitations. So I think, in view of this, plan fiduciaries need to build better walls against these potential attacks. So what can you do to help clients? Well, you've probably helped your clients already by setting up a good fiduciary process. You have a regular calendar of meetings to review plan matters. You bring important investment decision or information to their attention. You assist them with decision making. Perhaps you've helped them set up a plan committee or write a committee charter. So it's really a small step for you to help them play better defense. And you can do this, I think, by reviewing and improving existing processes. And I think this review should be systematic and recurring. You can help them apply leverage to get most out of their plan asset size in negotiating fees. And you can make sure they continue to get all the information they need to make important investment decisions. You can help them document their decisions, not just in minutes, but minutes are good, but any collateral sales materials or communications with vendors or candidates in a selection process should be kept. Finally, you can help your clients get the education they need about their plan specifically and about benefits generally. So all of this doesn't guarantee that your client won't get sued, but doing these things will help you and your clients, and all of this protects you and them. So I think, in conclusion, the 2016 litigation puts advisors and sponsors on defense and offense. If you do nothing, you're vulnerable. You need to have a defense. On the other hand, if you take small steps, the small steps I've discussed, I think you do two things. You'll address potential weaknesses in plan processes, and you'll actually improve the plans. So it's not really possible to cover all the nitty-gritty of fiduciary responsibility in the time we have. But if you're an old hand at this, you already know a lot of that. You know what good process and procedure is. You know how to build a team that includes TPAs, CPAs, and attorneys. You know how to use your internal resources to serve your clients. And really, you know how to make the whole greater than the sum of the parts. So, as I said at the beginning, you are better positioned to help your client than really anyone else. And you can do it building on what you already have. So if you have any questions, I'd be happy to take them at this point.
Chuck, this is Chris Barlow. Thank you for a great presentation. I just have a quick question for you. The cases you mentioned seem to involve large and jumbo plans. The question, is it really realistic that this type of legislation will reach smaller plans, the vast majority of plans in place?
Well, that's a great question. There was a a case last year involving a less than $10 million plan in Minnesota. It was the Lametri decision, and and that's very small plan litigation in comparison to what we have seen in the past. And I think we're going to see more. We're going to see that litigation drive down to small, that type of litigation drive down to smaller plans. And remember, there are 75,000 401k plans in the U.S. That have 25 million or fewer assets. So if we consider those small plans, there are 4.2 million workers in those plans. So I think there's a potential opportunity here for the plaintiff's attorneys to figure out how to get at those smaller plans.
Joanne, do you have some others that have come in?
Yes, we actually do. The first question that we have, is it a conflict of interest if the record keeper of a plan owns an IRA that is also the plan advisor on that plan?
All right.
So would you say that again, please?
Sure. Is it a conflict of interest if the record keeper of a plan owns the IRA that is also the plan advisor on that plan?
RIA.
RIA. Yeah.
Okay. Well, I mean, I think it depends on where the decision about how the RIA and record keeper are retained. I think it's possible to basically set up a consent structure that would make that type of arrangement acceptable and not a conflict of interest. But there's a lot of detail there that would have to be explored to figure that out exactly. But in concept, I think it doesn't have to be a conflict of interest.
Okay. Another question, what are your thoughts on BIC versus fee-based compensation going forward?
Oh, you got me. I think number one, we still don't have a final word from the Labor Department on what they're going to do with BIC, and I think that's really how they choose to handle it is going to be really significant in terms of responding to that question. My sense is that the Labor Department is going to make it a lot easier to operate under BIC in changes to the rule. We don't know what those changes are; they haven't been proposed yet. But I think those types of changes might make the BIC exemption and the receipt of variable compensation under it something that might be more acceptable to a wider range of folks. So I think the jury's still out on that one. I think we have to see what the Labor Department is going to be, what the Labor Department is up to, and any future changes to the BIC exemption.
Okay, Chuck, I have a few more questions. Do you want me to go ahead with those, or?
Yeah, I'll take a note.
Okay. You mentioned earlier that a larger plan should pay lower fees than a smaller plan. You mentioned based on plan assets. But in a zero revenue share world, a plan with $40 million and 1,000 employees should not be less expensive for a record keeper than a $10 million plan with 2,000 employees. Agree or disagree? And If you want, I've got names and things so we can maybe respond later.
Yeah, why don't I respond to that? Yeah, why don't I respond to that later?
Okay.
That's, yeah.
All right. So for the person that submitted that, we'll get back to you. And then the last question, are there any resources available to help advisors put in place or improve processes for plan sponsors? What to focus on, what to include? Great question.
Well, there are resources out there. I mean, I would start with the Labor Department website as a sort of a basic source of material and what they expect. There are. I'm trying to think of any specific resources. I mean. My book, for example, covers the general observations on those processes and procedures. But I guess I would say I'm not aware of any resources that like specifically hone in on that type of thing.
Okay. And then one last question that came in. Is the 401k averages book a good reference for fees and services for advisors?
Okay, here's what I think about those types of services. They sort of get you in the ballpark in terms of what fees are. The problem is they're, and I may be wrong about this, but they're not entirely current. And actually, there's really no substitute for doing a request in an RFI, a request for information, where you can sort of get you get a pretty good idea of what fees should be for a particular plan. So until you have a willing candidate out there that's sort of looking for the business, I find those types of services like that just generally helpful. Maybe it shows you a little bit about what's going on with particular size plans, but until you drill down into people who actually want the business and are willing to put some numbers on a piece of paper, I think you should take those types of services with a little bit of a grain of salt. In others, you shouldn't depend on them. They're a useful tool, but you shouldn't depend on them.
Yeah, I know you don't want to toot your own horn too much, Chuck, but Chuck's book that we publish on Aristopedia.com is a really good resource for a lot of insight and guidance. And if you go to Aristopedia.com, you'll see a little information about all the different products we have. But the Fiduciary Responsibility e-source, we can even set you up a real quick demo of it so you can see the content in it. And I think it's, Joanne helped me, it's like $145 a year. It's very affordable.
Yeah, $145.
Yeah.
And it's, I will toot my horn a little bit. And it also does have some nice tools, sample charters and other things that may be useful that I think are quite useful.
Yep. Thanks, Chuck. And we also want to thank Chris Barlow for sponsoring this with us. And I think a lot of you probably got invited from Chris. So again, if you need any more information, please give us a call, write us. You can also write Chuck directly with the email that's on the screen. You can visit our websites, and I'm sure you can also write and call Chris Barlow if you have any questions. He can direct you in the right direction. The recording will be made available. We'll try to send a link out to everybody, and we appreciate you attending, and have a great day and hopefully a good holiday weekend. Thanks, everybody.